and let the matter be listed after the
For the
petition.
petition. Learned counsel, you are for 3.
Yes, sir.
Mr. Nehru. Learned counsel appearing for respondent number 3. Seek some time to file. You'll file an affidavit.
Yes.
File an affidavit in opposition. The learned counsel for the petition has no objection. List the matter after 3 weeks. After 4 weeks, it will be. The vacation is there.
Oh, yes. But there's an interim, my lord.
Interim order by so and so date stands extended till the next date of list.
Much obliged, Lordship. Lordship, I can beg to mention item number 20, my lord. Item number 20.
21.
20.
20.
20.
Hearing not.
Lordship, on the consensus brief, this matter can be fixed on 14th of July, my lord.
Okay, you are for the petition.
I'm for the petition.
You are for the response. Learned counsel for the petitioner prays for adjourning the matter today and listing it on 14th July. No, Miss Learned counsel appearing for the respondent number 2.
Lordship, I'm for the sole respondent.
Sole respondent. There's no objection. List on 14/7/2026.
Much obliged, Lord.
Mr. Lordship, I beg to mention item number 10. Lordship, taken the consent of the opposite party, I beg before this honorable court to kindly list the matter after 2 weeks' time.
After
2 weeks' time.
2 weeks.
Yes, Lordship.
Learned counsel for the petitioner submits that with the consent of the other side. She's seeking posting of this matter after 2 weeks. Prayer is allowed. List after 2 weeks.
Lordship.
Yes.
Please, Lordship, I beg to mention item 5 on behalf of respondent 1 and 2. I pray for 2 weeks time to file.
You are for 1 and 2.
Yes.
Madam is for
For the
petition.
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 Lordship, let this matter be listed on 30 July.
The learned counsel for the petitioner and the learned counsel for respondent number 1 and 2 mutually seek posting of this matter on 30th July. Full stop. Any interim order?
Yes, interim agency.
Prayer is allowed. Interim order by so and so date stands extended in the next date of listing. List on 30/7/2026.
Obliged.
Please, Your Lordship. Your Lordship, I filed an IA in connection with item number 17.
1/7.
Yes. If the IA could be moved along with item number 17, unlisted.
You want it to be brought on record?
Yes,
today?
together. Yes, with item number 17.
Okay. Can be brought.
Much obliged.
Please, my lord. Lordship, I beg to mention item number 9. Here I'm for respondent number 4. Lordship. This respondent is complying with in the process of compliance with the honorable court direction, and I've also prepared affidavit updating the status. So can you grant it for more weeks time, Lordship?
Lord, for the petitioner. Lord counsel appearing for respondent number 5.
4.
4.
Yes.
Submits that the compliance with the or order passed by this court in connection with which the instant contempt proceeding has arisen is almost in the process of being complied with, and in this context an affidavit has also been prepared to be filed. Full stop. The learned counsel therefore seeks how much time would
4 weeks.
4 weeks time for the same. The learned counsel for the petitioner has no objection, right? List the matter after 4 weeks.
Bless you, Lordship. Lordship, item number 12 also, Lordship. Here, on the last occasion, so I have submitted that I'm for respondent number 4, Lordship. And that
Your names are not showing. The names, should I also mention that name should be shown?
actually, I'm also yet to file my bakala.
Oh, that's all.
That is over here.
That is right.
And he's transferred out of the state.
Okay.
So I'm still yet to do the necessary paper
Instructions.
So sometime may be required.
Learned counsel submits that he has instructions to appear on behalf of respondent 4.
Lordship.
Respondent 4. But as the said person has been transferred out of the state, Therefore, he needs some time to do the formalities to entire appearance and file pleading if any, full stop. The Mr. Sophie, learned counsel for the petitioner has no objection.
No.
At least after 4 weeks.
Fine, my lord. Kindly allow me to implead him then, the new incumbent. Kindly allow me to implead the new officer.
Okay, no, he has not been, he has been transferred out.
Yes, yes.
New person has to be implemented.
Yes, yes. Yes.
The petitioner side is at liberty to implead the new incumbent pertaining to respond number 4.
Lodge your lordship.
Oblige, my lord.
For motion from the supplementary cost list, item number 23.
Yes,
May it please your lordship. The
the
Brief.
provision. Yes.
earlier I filed one petition under 227. This honorable court was pleased to pass an interim. Then in the meantime, realizing that here is also a provision under the relevant rules for administration of justice and police.
Okay.
I have sought
So,
liberty to withdraw
ah,
and then file afresh. And
This one.
so this is the
fresh one.
a fresh one, yes, your lordship. So the brief facts of the case is that the present petitioner had a dispute with the respondent number 5 in the village with regard to reserve forest inherited from his forefathers. He filed a case before the village council against the respondent number 5. During the process, respondent number 4 came in, intervened, and said that the land belongs to him. The village ruled in his favor, but refused to pass any judgment or issue any copy of the judgment passed in favor of the respondent number 5.
The order of the Dupasi court was upheld.
Yes, by the TC, not the village. Actually, initially it was the village.
Village, then it was.
So then
upheld.
what happened was I filed a application before the deputy commissioner
Hmm.
because the deputy commissioner has supervisory jurisdiction over the village council to direct the village council to pass to issue a copy of the judgment passed by it so that I can file appropriate appeal before the appropriate authority. Instead of directing the village council to issue the copy of the judgment, the DC referred the matter to the Tobashes. The Tobashes took it as a case and decided against me.
No.
So I filed an appeal before the DC. The DC appealed the Tobashes
Order.
judgment.
Out.
So now I am aggrieved by the order because the deputy commissioner could not have converted a normal application into a case and handed it over to the Tobashes to take up the case. Your lordship will see the application which I submitted. Annexure A.
Just a minute.
Yes.
Okay. You want to show which page? The impugn order,
Annexure A, your lordship,
page.
page 22. Page
Okay.
22.
Uh-huh.
The type copy is at page 24.
Oh. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22 The village council passed the initial order.
Yes.
You preferred appeal
No, I did not prefer appeal. I asked for a copy of the
or
judgment.
copy of the judgment.
It was not given, so I approached the deputy commissioner to direct the village council to issue its judgment, a copy of the
Okay.
judgment, because under the rules,
Okay, but it was,
but it was, yes.
it was decided by the.
Yes,
commissioner.
the deputy,
Two junior subordinate officers,
yeah, the deputy commissioner referred the matter to the DBs.
SDO.
And then the DBs took it up as a case.
I get it.
Yes.
So are you
So-
taking a stay at this stage?
Yes, Your
On
Lordship,
the next returnable date?
Your Lordship, I would prefer a stay if the status quo may be
Maintained
maintained. Yes, that would be
till
sufficient.
the returnable date.
Yes.
Heard, Mr. Learned counsel for the petitioner, who has preferred this civil revision under, now you are preferring under Rule 32. right?
32, yes.
Rule 32 of the
Rules for
Rules for Administration of Justice and Police in Nagaland 1937. Within bracket, hereinafter the rules, bracket close. Agreed by orders dated 28/7/2025 and 20th August 2025. Sorry, this is not this one. The impugn, agreed by the impugn judgment and order dated 17/11/2025. It was passed by the SDO,
DC, Deputy Commissioner.
the learned Deputy Commissioner Samato, upholding the order dated 29/6/2022, passed by the Village Council of Sangpur, SANG, PHU. It is submitted by the learned council and that
Your Lordship, sorry, Tobashis of the Shamador, not by the village council.
the initial dispute was regarding ancestral reserve forest at Sangpur village. And it is submitted that despite evidence to the contrary, the case was decided in favor of respondent number 4. It is submitted that the petitioner sought a copy of the judgment which was not being made available to it, and subsequently also moved the deputy commissioner of Samator for the same. However, the deputy commissioner by a letter dated 25/6/2024 referred a legal notice dated 28 June 2024 submitted by the petitioner to the Dopasis Court Samator for disposal. And by judgment and order dated 10/7/2024 held the rights of the land in favor of respondent number 4 first. It is further stated and submitted that agreed by the said judgment and order dated 10/7/2024 passed by the Dobashi DB Court Samato, the petitioner preferred an appeal under Rule 31 of the rules before the Deputy Commissioner Samato, who entrusted the hearing to SDO Samato, and the present impugn judgment against which present impugn judgment dated 17/11/2025 against which the revision has been filed came to be passed. It is also submitted that earlier a writ petition was filed under Article 227 of the Constitution of India, but it was withdrawn with liberty to file a fresh petition, and accordingly the instant revision has been filed under Rule 32 of the rules, which provides for the same. It is submitted by the learned counsel for the petitioner that at this stage till the returnable date, an order of status quo may be passed, so that there are no complications in the litigation. Who's appearing? You accept
I'm for state respondent number 1 and 2, Lordship.
1 and 2. Current government advocate appears and accepts notice on behalf of respondent number 1 and 2, within bracket the state respondents. And 3 and 4, 3, 4 and 5, 4 and 5, of course, you have to issue notice. Customary court also you have to issue notice.
Yes, Your Lordship.
The petitioner shall take steps by speed post,
Your Lordship.
upon respondent number 3, 4 and 5. The petitioner is also at liberty to resort to dusty search,
Your Lordship.
and in that event, a compliance affidavit shall be filed. Full stop. Status quo as on,
Yes.
as on,
Today, Your
as
Lordship.
on today.
Yes, because
It
the
has not
status
been
quo, the earlier
executed.
status quo is still continuing. Yes.
After the vacation, after
Your
4
Lordship.
weeks, upon considering the matter, the parties shall maintain status quo over the property in question,
Your Lordship.
prevailing as on today. That's 18/6/2026 till the returnable date. Please the matter. After 4 weeks, we can fix a date. After 4 weeks on, we can fix a date. 1, 2. Put 15 July,
Your Lordship.
15 July.
Yes.
Okay,
15 is a witness.
15 7.
When is Wednesday?
This is where, oh, sorry,
16?
15 is Wednesday.
Yes,
So it
16.
has-
16 will,
14 or 16.
16 will do. Much obliged.
For motion, item number 24.
May it please your lordship. Lordship, by this petition, I am invoking contempt jurisdiction of this honorable court for non-compliance of judgment and order dated 10/1/2026, passed in WPC 94 of 2022. Lordship, this matter relates to non-compensation of,
Right.
yes, for the damages of my property, lordship. And this honorable court has was pleased to direct the respondent number 1, 2, and 3 to pay compensation, lordship. Lordship, may kindly see the operative para of the judgment at page 37, lordship. Para 55, lordship.
Said amount shall be
The said amount of rupees 1,16,47,063 only shall be paid by the respondent to respondent number 1, 2, and 3 to the petitioner within 3 months from the date of this order. After making payment to the petitioner, the NHIDCL may invoke the indemnity clause of the EPC contract between itself and EPC contractor to get reimbursed by the EPC contractor in respect of the compensation paid by me to the petitioner. Now, lordship, the time has already expired on 24/2026. Until now,
28 April.
20th April.
Right.
Until now, no payment was forthcoming, lordship.
You'll have to issue 2 and 3 are the national highway
Yes,
and
lordship.
a corporation, right?
Lordship.
Oh, full stop. Mr. Casey,
TKG.
learned counsel for the petition. Full stop. The petitioner has invoked the contempt jurisdiction of this court, agreed by purported willful disobedience of order dated 28 January 2026, passed by this court in WPC 94 of 2022. Give a dash, whereby the court has granted compensation of rupees 1,16,47,063 for damages caused to his building and other property due to the construction of the Dimapur Kohima 4-lane road undertaken by the NHIDCL. The learned counsel has drawn the attention of the court to the pertinent para 55 of the judgment, which may be extracted here in below at page 37. it is submitted that the period of 3 months given for compliance with the order expired on 28 April 2026. The petitioner shall take steps by speed post for issuance of notice upon the 3 respondents.
Lordship.
This is the matter after 4 weeks.
Lordship. I'm obliged, Lordship.
For orders, item
The
number,
orders, quickly go through it. Yes, orders.
for orders, item number 11.
Yes.
May please, Lordship. Lordship, here, as per the state's affidavit, the case has been complied, so if this contempt petition can be closed.
Has been complied. I grant counsel appearing for the contempt petitioner submits that the order in question being order dated, just helping with this. Order dated 14/11/2024, passed in WPC 554 of 22, passed by this court, has been complied. Madam, Speed Supreme, Learned Counsel, Learned Additional Advocate General, appears on behalf of
Respondent number 3, 5, and 6.
6 is newly,
Yes, included.
3, 5, and 6. First,
Lots of time for respondent number 4. Deputy
3, 5, and 6, 4.
I am for respondent number 1.
1 and 2. What about 2?
1.
2 is?
To already,
It's okay. It's okay. In view of the aforesaid petition submitted by the learned counsel for the petitioner, I do not deem it necessary to keep this contempt proceedings pending. Therefore, this contempt proceeding stands closed and disposed of.
For orders, item number 13.
Yes,
May I please, my lord? My lord, in this case, my lord, service upon respondent number 6, that is owner, is still awaited, my lord.
you are for the
For 1 to 5, respondent 1 to 5.
claimants, the claimants.
Respondent claimant.
Mr. Did not appearing on to the online mode submits that in the IA in this IA service report is still awaited with regard to respondent number 5,
6, my
5 and 6,
only 6, my lord.
only 6. Learned counsel appears on behalf of 1 to 5.
1 to 5.
The claimants. Await service report on respondent number 6. This is the matter after 4 weeks. Okay.
Obliged, ma'am.
For orders, item number 15.
May it please, my lord. The petitioner herein is the uncle of the accused person. The accused person was arrested on 18th November 2025, my lord.
Okay.
And thereafter, a charge sheet was submitted on 4th February 2026.
Right.
And the case of the prosecution in a nutshell is that the accused person had on 12th
Yes, you are
November, my lord.
Attempted.
Lordship, that, yes, however, Lordship, actually, at the time of consideration of the charge, if my lord will have para 23, my lord, here is a case where the allegation of rape was raised most arbitrarily, and initially the FIO was registered under the offense of rape and also breaking and entering. However, in the course of investigation, and thereafter, the charge sheet revealed that there was no element of rape, my lord. Therefore, if my lord will have para 23, this is the order dated 21/4/26, wherein charges were framed. And during this time, my lord, to save time, I will not be reading the entire text, but if my lord will have the last para of page
Yes.
23, my lord.
Yes.
Countering the submission of the counsel of the accused, the prosecution has made it clear that the charges of attempt to rape or murder does not arise and therefore has not even prayed for framing charge of these offenses. I have heard the submission of the prosecution and also on the counsel appearing for the accused, my lord. And therefore, charges were framed only, the charge of rape was dropped and charges were altered. Charges were for attempt to commit an offense, assault, outraging modesty of women, house trespass, grievous hurt. Lordship, thereafter, the accused formally pleaded not guilty and the matter was fixed for examination of PWs. In that regard, my lord, only the other day, 2 days, 2 days back, the victim was also examined, and my lord will find in the FIR, my lord will have para page 26.
Victim has also been examined.
Lordship, yes, day before. And my lord will find in the body of the FIR at page 26.
Yes, I'm on.
Yes, Lordship. There's 3 paragraphs here. The second paragraph states, on preliminary inquiry, the victim family members refused to lodge any FIR against the alleged culprit, citing that they have promised to forgive the culprit if he states the truth in the spirit of a true Christian. Lordship, therefore, this was a case where even before registration of the FIR, the parties have mutually resolved the matter. However, an FIR was registered suo motu. Therefore, my lord, there is no possibility. The victim and the accused person. There's no animosity as such at this time. And as stated, the victim's statement was also recorded the other day. I have a copy of the Honorable Court's order, the trial court's order, wherein the matter, Lordship, this is a CTC of the order of the trial court. The victim has been examined and the matter has been further fixed for examination of other witnesses.
Okay.
If my lord will have page 16 now. Page 16, this is the relevant page of the arrest court surrender memo. Here, the IO has made certain observations at entry number 12. Whether the arrested person, as per the observations and known police records,
Or
Lordship,
no.
yes, amongst others, previously escaped any bail? No. Is a recidivist? No. Is likely to jump bail? No, Lordship. Therefore, my lord may kindly give due consideration to this. Accused person is only 23 years of age at this time. He has remained in custody for a period of 212 days till today. And further, remanding him with hardcore criminals convicted and other UTPs may not be in the interest insofar as this development as a young person is concerned. The allegations of sexual offenses are completely unfounded. There is no material findings in this regard. The accused has been rendering his full cooperation to the IO till date and also to the court. There is no absconding as submitted earlier. There is no possibility, my lord, that he will tamper with evidence or induce or threaten witness at this stage. And therefore, my lord, if at all he is given the liberty of bail, then he will certainly abide by any terms and conditions. Lordship may permit me to refer to some authorities now in this regard.
Can I just, I'll come back to.
Your Lordship, may kindly see the order dated 11/6/2026. By this order, record has been called from the
Records has come.
first come.
You have the records?
No, my lord.
Records has come. It is there in the listing. But I think,
My lord,
yeah, but since victim has been examined, I think we can pause it.
my lord, if the record has come, then kindly allow me 10 weeks, 10 minutes to go through the.
Yeah,
record.
sure.
Yes.
No problem.
Then the matter can be listed, taken up after the.
After some
the matter,
time.
yes.
After some time, I'll just. Okay. After some. After some time.
For orders, item number 16.
May I please, Your Lordship?
Yeah.
In compliance to order dated 21/5, on 26/5, I've taken step for service of notice upon the sole respondents
Okay.
through speed post as well as usual process.
Okay. It's awaited.
Yes.
Services are. Yes, prepared.
No, Your Lordship, I have been briefed for respondent number 1.
One.
Yes.
Sole response.
Lordship, I'll be appearing for respondent number 6 to 7.
There are two respondents. Quite a couple of them.
Yeah,
Eight respondents.
eight respondents, Your Lordship.
I will be appearing for responding.
Learned counsel for the petitioner. Mr. Jimomi for respond number
3 to 7.
3 to
3 to 7.
3 to 7. And Mr. Hangami for respond number 1. But who's remaining then? 8.
Yeah.
Respond number 8.
Yes, Lordship. Service upon 8 is.
Okay, submitted that, so steps have been taken. Service is awaited with regard to respond number 8.
Respond number 8 and 2. PNR.
Okay. 2 and 8. List the matter after 4 weeks. After 4 weeks. Have you filed any pleading?
No.
In the meantime, the respondents, the learned counsels for the respondents who have appeared so far are at liberty to file their affidavit. Compliant order.
For orders from the supplementary cost list, item number 25.
What is the IA about in the first appeal?
May I please, Lordship? My Lord, here I'm mentioning on behalf of MD Mr. Additional AG, my Lord. My Lord, I'm informed that this matter has been settled through mediation, my Lord.
Okay, very good.
Then
Please
matter will be lost.
receive the final report submitted by mediator, so successfully. All right, so
It can be closed here.
it can be closed.
Yes.
The report shall be part of the order.
Pardon?
The mediation report can be part of the order
Yes, Your Honor. Yes.
and or kept in the record.
Yes, Your Honor.
Full stop. Full stop. It is submitted by both the land councils that in the meantime, the matter which was referred to the mediation center has been successfully settled. So, in this regard, I also perused the office note dated 17/6/2026. It states that final report has been submitted by Mr. Italang Ramlia, mediator, stating that FA number 4 of 2025 has been successfully settled through the mediation process. The mediation report is the mediation report dated 15/6/2026. No, so this is the letter. The final report dated 15/6/2026, as well as the mediation settlement agreement is available in the case record and marked it as flag A. In view of the successful settlement of the case through mediation, which is appreciable, give a dash. The instant matter can be closed, and the same is also submitted by the learned councils about the service. According the instant proceedings stand disposed of upon settlement.
Yes.
Upon settlement through mediation. The mediation report shall constitute part of this order, except in the case report. Okay.
Much obliged.
Much obliged.
For admission.
May I please,
item number 2.
May it please your lordship.
Yeah, please, Lord. My Lord, I'm mentioning on behalf of Livika, Council for the State, my Lord. I'm informed that she's yet to receive CD. So, my Lord, kindly allow,
This is
kindly list the matter after the vacation, my Lord.
this is for quashing of FIR.
Yes.
Fire as well as and the two matters are the item number 2 and 3, my lord.
Yes, pardon. Can you repeat what you said?
My lord, item number 2 and 3 both are same petitioner, my lord. One is for quashing of NBWA and other is for quashing of FIR, my lord, arising out of same PS.
Okay, one is for quashing of what? Apart
FIR and other is for causing of NBWA, my lord.
NBW.
My lord.
In both the cases, there is an interim order, right?
Yes, my lord.
So anyway, case diary will be necessary.
Yes.
My lord.
The
My
FR
lord.
will be necessary.
Yes.
My lord. My lord.
You are Mr. Mishra,
Mr. R.S. Mishra, my lord.
R.S. Mishra, learned counsel for the petition. You are appearing in both the cases, right?
My lord.
You write separate also for the appearing online through the online mode. Submission is made on behalf of Ms. Devika, learned public prosecutor.
Yes.
That the case diary has not yet been received, comma, which will be necessary for adjudication of these proceedings, and praise for listing the matter after
Vacation bonus.
after the vacation, summer vacation.
Lordship, the date need to fix it.
I'll fix it.
It can be 27th of July, my lord, if lordship permits.
27th of July.
July.
I can fix it. Is it okay?
Yes, sir.
The interim order white order dated 7/11/2025 stands extended till the next date of listing. Okay, list the matter on 27/7/2026. This is item 2. Okay. This it also writes scan copy of the GR 412 of 25 is available and maybe tagged with the record.
But interim order is there in both the cases, my lord.
Huh?
Interim order is there in both the cases.
Interim order is on the same day.
Same day in both the cases, my lord.
Okay, so you might write the same order. Write the same order. In 3 also you write the same order. But the GR GR would be is arising out of the same case.
Same case, my lord.
Then GR would be same. Okay.
Much obliged.
Deeply obliged, my lord.
My lord,
For
Lord,
admission,
I have
item number 4.
Just a moment, Mr. Devnath. Just a moment. Speaking yourself.
my lord.
All right, item 4. Yes.
May I please, Lordship, the IA is filed under Section 5 of the Limitation Act 1953, seeking continuation of 177 days in preferring the appeal. Here, the appellants are the family members of the deceased who died in a motor accident case. Here the
What happened to they were not awarded? Award was
he
not,
was awarded, but he was awarded in a minimum.
you were seeking enhancement.
Yes, I'm seeking enhancement. And the delay was not intentional, my lord. And after the appellant came to know that there is a scope for enhancement under the Section 173 of the Motor Vehicle Act, they approached several advocates, but none of them were willing to take up the case. So finally, after they engaged a lawyer, they filed this instant appeal, my lord. So since the delay was not intentional.
All have appeared, right? You are appearing for the insurance company, right?
Yes.
Response number 1, 2 and 3.
Yes.
2 and 3, you are appearing.
2 and 3, we have served them dusty and we have filed the compliance of the dusty.
They have not appeared.
Yes, ex parte.
Yes. You can make your submissions with disposition of.
I file my written objection. Corresponding number 1, Your Lordship. If I may read my paragraph 2 and 3, Your Lordship. That as stated by the
Just a minute, you have stated your grounds in which paragraph?
Para 3.
Para 3?
Para 3. Yes. Para 3, 4.
Hundred and 77 days. Okay. Where is your objection, madam? So The compliance of it. Fine. Fair.
Para 2, Your Lordship, page 2. If I may read, Your Lordship.
Yes.
That as stated by the appellant claimant in para 6 of the IA Civil 103 of 2025, praying for condemnation of delay of 177 days, where the appellant failed to mention the cause of delay and also the facts that has been stated in the MAC Appeal 11 of 2025 in para 4. The claimant appellant have received awarded amount of rupees 4,03,000 along with interest of 1,33,713 on 19/11/2024, Your Lordship. I've also annexed it in my annexure 1, page 5, Your Lordship. Para 3, that the appellant claimant should have preferred the appeal before receiving the total award along with the interest. It only shows that the appellants have come forward and preferred the appeal only for benefiting from the company and not with genuine cause, Your Lordship. Your Lordship, sufficient cause should be explained as per Section 5 of the Limitation Act. No date or any documents to support their statement made in para 3 of their IA for condoning the delay has not been mentioned. Not even a single date is shown, Your Lordship. Moreover, in their main appeal in para 4, page 8 of their main appeal, they have already admitted that they have already received the amount.
Yeah, that's okay.
Yes, Your Lordship.
But do you think there is any error in the judgment of the tribunal in awarding? Should have been
Yes.
more. And
Yes,
3,000 was taken as notional income for a cultivator.
Yeah, it's very less because
It was a bachelor.
yes,
50% deduction has been made.
yes, yes.
So those are okay.
Yeah.
So you are only agreed that the notional income should have been higher than
Yeah,
3,000.
it will be 7,000. It will be 7,000 per month. So 84,000 annual. But mine was
Seven on what basis you're saying? 7,000.
because as a farmer, I earn not only from the sale of the PD but I also earn as a daily wage.
Okay.
Daily wage
Think that,
labor,
by
depending on
the present standards, it should be
Yeah.
7,000. That is what is said.
Yeah.
No, are you, if you are using, I was meaning to ask that, are you using some case law or whatever, some minimum wages or whatever, something of that sort? But rough estimate that it should have been more than 3,000.
Yes, ma'am.
Well, anyway, yes, she's also right that no dates have been mentioned. That's true.
Yes, Your
No dates
Lordship.
have been mentioned.
No sufficient cause has been mentioned, Your Lordship.
But if you see it from the point of view of beneficial legislation, maybe it can. Otherwise, yes, the councils which were approached said that there's no
Yes, ma'am.
merit. He stated that honestly.
There's no other.
Even to Your Lordship, if I may cite one citation, Your Lordship.
Actually, in delay condonation, though there is not an absolute bar, but basically we do not go into the merits of the main matter. Usually we focus on the grounds of delay, right? Grounds of delay. Yes, please.
Yes, if I may submit one citation.
Living medium.
2003 Supreme Court case 563, Your Lordship. Lordship, para 24, Your Lordship.
Era 24.
Yes, Your Lordship. I've underlined the effective portion. If I may, Your Lordship. After referring various earlier decisions taking very lenient view in condoning the delay, particularly on the part of the government and the government undertaking the Supreme Court observed is under Mundik Kamal case SCCPP 475/50 in paras 29 and 30. Your Lordship, para 29, which I've underlined. It needs no restatement at our hands that the object for fixing time limit for litigation is based on public policy fixing a lifespan for legal remedy for the purpose of general welfare. They are meant to see that the parties do not resort to dilatory tactics, but avail their legal remedies promptly. Salmon, in his jurisprudence states that the law come to the assistance of the vigilant and not of the sleepy, Your Lordship. And also, Your Lordship, if I may read para 27. Next page, Your Lordship. It is not in dispute that the persons concerned were well aware or conversant with the issue involved, including the prescribed period of limitation for taking up the matter by way of filing a special leave petition in this court. They cannot claim that they have a separate period of limitation when the department was possessed with competent persons
This
familiar.
was in the context of comment. Anyway,
Wait, yes,
in the absence of,
yes.
you can read it, in the absence of plausible and acceptable explanation. You can read, complete reading.
In the absence of possible and acceptable explanation, we are posing the question why the delay is to be condoned mechanically merely because the government or a wing of the government is a party before us. Para 28. Though we are conscious of the fact that in the matter of condonation of delay, where there was no gross negligence or deliberate inaction or lack of bona fides, a liberal concession has to be adopted to advance substantial justice. We are of the view that in the facts and circumstances, the department cannot take advantage of various earlier decisions. The claim on account of impersonal machineries and inherited bureaucratic methodology of making several routes cannot be accepted in view of modern technologies being used and available. The law of limitation undoubtedly binds everybody, including the government. Para 29, in our view, it is the right time to inform all the government bodies, their agencies and instrumentalities that unless they have reasonable and acceptable explanation for the delay, there was bona fide effort, there is no need to accept the usual explanation that the file was kept pending on several months yearly due to considerable degree of procedural red tape in the process. The government departments are under a special obligation to ensure that they perform their duties with diligence and commitment. Condonation of delay is an exception and should not be used as an anticipated benefit for the government department. The law shelters everyone under the same light and should not be spoiled for the benefit of a few. Considering the facts, para 30, considering the fact that there was no proper explanation offered by the department for the delay, except mentioning of various dates, according to us, the department has miserably failed to give us any acceptable and cogent reason sufficient to condone such a huge delay. Accordingly, the appeals are liable to be dismissed on the ground of delay, Your Lordship.
Okay.
Lordship, there is no sufficient cost given by the appellant, Your Lordship, and also they have approached the court after 19 months, Your Lordship.
On 77 days. Take part of the application. Completely. Sit down, please. Take 5 minutes. Third stuff. And for the respond number 1. Let's do. The instant interlocutory application is has arisen out of an application filed by the prospective appellants under Section 5 of the Limitation Act, seeking condonation of delay of 177 days. Sit down. In preferring an appeal against judgment and award dated 27/9/2024, passed by the learned member MACT Dimapur in MAC case number 99 of 2017, whereby the applicant applicants as claimants were awarded an amount of rupees 4,03, 0,000. What was the interest amount along with interest at the rate of
6%.
interest at the rate of 6%? Close to. The learned counsel appearing for the applicant. In support of the grounds adduced for condonation, has drawn attention of the court to para 3. Para 3. It is submitted that the 4 applicants are the family members of the deceased who was killed in the road accident. It is stated and submitted that initially the applicants were not even aware that there is a provision for appeal for enhancement of the claim amount. It is also stated and submitted that after coming to know about the said legal petition, they approached several learned counsels, but none were willing to take up the matter on the ground that there is less chance for enhancement of the claim amount for the tribunal. Eventually, they engaged the present learned counsel for preferring an appeal, but in this process there was a delay of 177 days, for which condonation is being prayed for. It is also submitted on behalf of the applicant that service by Dusty was taken upon respond number 2 and 3 within bracket owner and driver bracket close, comma, followed by filing of compliance affidavit, comma, but they have not chosen to appear. However, respondent number 1 is the insurance company who has entered appearance with the learned counsel, has been mentioned above. The insurance company has filed a written objection stating that the delay has not been explained properly. It is also stated and submitted that the awarded amount along with interest amount of rupees 1,33,713 was received by the claimants on 19/11/2024. Stop. It is stated and submitted that only after benefiting from the award, they have chosen to file the instant appeal. In support of our contentions, the learned counsel refers to the decision of this one, the Postmaster General versus Wednesday, and draws attention of the court to para 24, 27, 28 to 32. I perused the materials and considered the rival submissions, comma, including the decision cited at the bar. The principle behind it's well said that the principle behind prescribing limitation periods is to give a finality to the litigation. The expiry of the limitation period gives rise to a right in favor of the other party, and that aspect cannot be overlooked in considering the question of condonation of delay, comma, especially in a civil dispute. Good stop. The relevant the para 24 and 20 para 24, 28, and 29 of Postmaster General Supra may be reproduced herein below. That case was one pertaining to next para. That case was one pertaining to government departments. And the court and the Honorable Apex Court, observing that limitation applies equally to the state as well, did not find the explanation sufficient and refused to condone the delay. Full stop. The learned counsel for the insurance company has also contended that no specific dates have been mentioned in the explanation for condonation of bill. Full stop. Full stop. In a proceeding under claim proceeding under the MB Act, the beneficial nature of the legislation would also have a bearing on the aspect of delay condonation. Full stop. In the case of in the Postmaster General Supra, the court was not convinced about the bona fides of the case for delay condonation. Full stop. However, in the instant case, the explanation projected by the applicant side do not indicate any lack of bona fide. Rather, it has been frankly stated that the claimants, the applicants who are family members of the deceased did not know about the provision, and their request for filing an appeal was refused by several learned counsels on the ground that there is no sufficient merit. Full stop. I also take note of the submission of the learned counsel that the deceased was stated to be a farmer, and the learned tribunal took a notional income of rupees 3,000. And in this context, the learned counsel submits that the learned counsel submits that in quantifying the notional income at rupees 3,000, perhaps the tribunal earned on the lower side. Upon giving consideration to the various aspects of the matter, I am of the considered view that the applicants who are family members of the deceased should be given a chance to prefer the appeal for enhancement. In such view of the matter, the delay of 177 days is hereby condoned. IA stands allowed and disposed of. The appeal may be put up for admission hearing subsequently.
Gotcha.
Item number 15.
Okay, this bail petition. Take this. You can stop. Okay, sir. Thank you so much.
May I please watch him? My lord, I have gone through the reports and the charge sheet. I have gone through the charge sheet and the recording statement of the victim and the medical report of the victim and the accused. And my lord, when I go through, there is 3 facts have to be considered by this honorable court, my lord.
Yes, go ahead.
My lord, statement of the complainant and the statement of the accused and the statement of the victim and the statement of the doctor, it corroborates each other, my lord. And by this, you can see that incident was happened, and the accused also admitted that he has committed the crime, my lord. And the second point is, my lord, accused was apprehended and assaulted by the public, my lord. It is also admitted that assaulted by the public and kept at sawmill in New Market Colony, and he was beaten up by the public, my lord. And the third point is, my lord, accused and victim are residing in the same place. They are from same colony.
I've found it.
Yes. So, my lord, my humble submission is the nature of the case is very sensitive, my lord. At this stage, if the accused is released, my lord, and then
He's how many witnesses remain to be examined? I think so. Only 6 witnesses, I think, listed
Yes.
in the charge sheet. So if you see the number of the, which is PW3, I think halfway through examined 29.6. PW4 is fixed on 29.6.
Yes.
So
So, my
we
lord-
can look at it that way, or we can look at it from this way also, that victim has been examined. He has been there for a long time, but the one area of concern is that he is a neighbor. So we have to impose stringent conditions.
and my lord, not only that, another point is that he was apprehended by the public. He was beaten up by the public. At this stage, if the accused is released, whether it will be safe for the public, safe for the accused or not, that aspect you have to consider, man. For the safety of the accused, I'm submitting. And my lord, if they are never done, if the accused is
That
released,
is the area of concern.
yes, and
true.
my lord, if they
Actually,
encounter,
the girl suffering from disability, she cannot
yes,
speak.
and yes, disabled person, my lord. The victim is a disabled person.
Lordship, the family of the accused person has relocated after the incident. First, my
He's
lord.
not staying there.
Yes, Lordship. And also, with due respect to my learned friend's submission, this is an extrajudicial confession. My lord knows that the evidence law does not admit such confessions. Also, Lordship, none of the sections under which the accused has been charged have statutory presumption. And therefore, at this time, the accused is an innocent person in the eyes of law.
Can I see the victim's deposition is not here, I guess, right? But 164 would be here. Right? 164, have you found 164? The victim's 164,
Yes, my lord.
magistrate recorded before
Yes,
magistrate.
yes.
It is there. I have the GR report, but you have shown me the order, but the deposition is not there, right?
Yes,
Deposition, no.
the position is not there, man.
I can see the 164 statement also. That will also do so to some extent.
Yes, Lordship.
164 should be here. It's not POXO. It's,
No, Lordship, it's not POCSO. My lord, may have a look, 164.
well, he was under the influence of alcohol as per his statement. The problem is.
If anything, my lord, it is a case of theft.
Okay, no, this 164 does not per se make out a sexual offense.
I'm sorry,
Does not make out a sexual offense.
Lordship, no, it
Or
does not.
164 per se.
Yes,
Per
Lordship.
se. You cannot prejudge. of course.
Lordship, yes.
So we do not know what she has did because on the night of I was sleeping in my room. We can read it out. A
Right.
man so and so from different village came and grabbed my jaw chin.
Yes,
So she showed and hurt me, and I had bleeding from my mouth. Okay.
yes,
So,
yes, Lordship.
trespass, hurt. These sections can be trespass.
Yes, Lord, yes.
Trespass,
That,
hurt,
Yes,
can be,
Lordship.
but attempt to
Lord,
emerge from here. There's nothing, not a mention. I don't know what she has said.
Yes, Lordship. The records will indicate that the FIR was registered after 6 days when
Fair to
word,
give break.
yes, the police station
We'll
learned of
we'll impose conditions.
my lord.
You call someone. Should have been here in the record. This statement must be here. Must have missed. Can you have a look? Just flag it. You can just flag it. Mr. Page,
My lord.
your good name?
A. Kire, Alizo Kire.
Okay. Also Kide, learned counsel for the petitioner and learned public prosecutor for the state matter. Still, invoking the provisions of 483, please have a seat. It's already written here in the previous order. We can take it from first two paragraphs. You can take it from. The scanned GR record has been received from the Court of the Learned Session Judge Kohima. First step. In support of his case for grant of bail, the learned counsel, Mr. Learned counsel for the petitioner, Mr. Kire, learned counsel for the petitioner, submits that in the meantime, the victim has also been examined and he has submitted a copy, certified copy of the order passed by the learned session judge regarding the same. Full stop. Learned counsel submits that the petitioner has been in custody for a considerable time ever since his arrest on 18/11/2025, and that the trial has also progressed. With regard to the aspect of the accused being the neighbor of the victim, it is submitted that in the meantime he has also relocated to another locality. On the other hand, the learned counsel for the learned public prosecutor opposes the bail at this case, submits that the nature of the alleged offense has to be seen, and the fact that the petitioner he happens to be the neighbor of the victim who also suffers from disability in the nature of hearing and speaking. It is further submitted by the prosecution that prior to his apprehension in law, he was assaulted by the members of the public, and therefore release on bail might also raise concerns about his safety. I have perused the relevant materials and given my consideration the submissions. The statement of the girl was recorded under 183 BNSS during investigation for the learned CJM Kohima. The learned CJM, before recording the statement, proceeded to ask some preliminary questions, and thereafter, being convinced, proceeded to record her statement. In the statement, the victim girl has stated that on the night of the incident, while she was sleeping in a room, a man whom she named came from a different village and grabbed her jaw/chin, hurt her, and she had bleeding from her mouth. Next paragraph. The allegation in the other with regard was fire was pertaining to attempt to rape on the part of the if person first. Considering the length of detention, semicolon, the progress of the trial within bracket, including examination of the victim, bracket close, semicolon, the nature of the statement as mentioned above, dash, I'm of the considered view that it would be justified to grant bail to the petitioner, to the accused, at least is subject to suitable conditions. Next paragraph, in such view of the matter, he is hereby allowed to go on bail of how much? It can be 40,000, 40,000, 30,000.
Bail bond.
40,000 with one surety of the like amount to the satisfaction of the learned session judge Kohima, subject to the condition that he shall not abscond, not hamper or tamper with evidence, be available for trial, remaining trial, shall not harm or harass the victim in any manner. Violation of the bail conditions would entail cancellation.
I'm deeply obliged for
Shall stand disposed. Take this.
For admission, item number 6.
Item number 6.
May I please, Lord.
Also bail.
My Lord, bail application, man. May I read out the facts, my Lord, page 3, paragraph 1. Just short facts, so the Lordship will have a better understanding of the facts. May I read it, paragraph 1, page 3, man. Page 3. Here our grounds is that section 47, 48 are not complied.
This petition is for caution.
What? For releasing the bail.
Bail.
Yes.
Oh, I see.
My Lord, for
Sorry.
bail application, my Lord.
Yes, yeah, bail.
May I read paragraph 1, my Lord? Page
Yeah,
3.
Page 3.
That the applicant petitioner in the present case is the cousin of the accused person, namely Keystone accused 2. There are 2 accused matter here. The brief facts of the case is that on 5/5/26, while the mobile unit patrol party police were conducting routine duty under the jurisdiction of Kohima police station, it was alleged that a vehicle Maruti Alto bearing registration number so-and-so was approaching from Kohima village towards Viswama village in a suspicious manner. The duty party stopped the said vehicle and on questioning, the owner cum driver of the vehicle, Mr. Karamo Isaiah, accused 1, has started behaving in a suspicious manner. Well, this is relevant as far as accused 1 is concerned. Under such circumstances, the OC Kohima was informed accordingly. The OC Kohima PS and independent witnesses reached the place of occurrence at Viswama Kedima approach road. While search was conducted in the presence of OC Kohima and independent witnesses, no body search was conducted on the body of accused 1 and accused 2. It is alleged that while checking the vehicle, 25 soap cases containing suspected heroin, weighing about 302 grams, was recovered from the body of the vehicle. It is further alleged that the seized vehicle was found concealed in the rear pockets of the front car seat and the car speaker chamber. This is a relevant because there are 2 accused. I am a just mere passenger. It is further alleged that the car was in possession of accused Karamo accused 1. The complainant has categorically stated in the suo motu complaint that Mr. L. Keystone accused 2 simply accompanied the accused 1, but was taken into custody along with accused 1 without any material evidence. Thus, on perusal of the suo motu complaint, the involvement of accused 2 is not demonstrated in any manner. There is no allegation that the alleged seized drugs were found from the conscious possessions of accused 2.
There is no mention in the complaint that accused 2 has knowledge of concealing the alleged recovered drugs in the body of the vehicle, nor conspired to commit any offense in the present case. In fact, accused 2 was a mere passenger, having no knowledge that the alleged seized drugs was concealed in the vehicle and carried by accused 1. Accused 1 and 2, accused 2 is an innocent victim in the present case. Paragraph 2, my lord. That based also, this is the case, para 3, my lord. Para 3. That the applicant begs to state that on 5/5/2026, vehicle search was conducted by the police. Thereafter, this is relevant, my lord. Thereafter, property search and seizure memo under section so and so BNSS 2023 was prepared by the IO of the case. Deputy SP DYSP K Vekatochishi NPS. In the said property search and seizure memo under column 5, the name of accused 2 does not appear in the seizure memo, seizure form, except the name of accused 1. The relevant column 5 of the property search and seizure memo form is reproduced as under. Quote, column 5. Person from whom seized oblique recovered. Name Karamo Isaiah. Father's name so and so. The above seizure memo has further proof beyond reasonable doubt that there is no prima facie case against accused 2 in the instant case. Paragraph 4. That in the instant case, the notice under section 47 BNSS 2023 is issued to the accused 2, which reads as follows. Quote, ground of arrest. To Mr. A.L. Keystone, son of so-and-so. I, Hucho Dazo, rank ASI, posted at police, so-and-so. Hereby inform you that you are being placed under arrest, the provision of BNSS. The specific ground of your arrest are as follows. This is important, my lord. That on 5/5/26, you were found to be involved in illegal possession. Illegal possessions of what? That is not stated. Illegal possession, only illegal possession. Page 6. That sufficient material and evidence, including so-and-so, establishes prima facie case against you. 3. That your custodial interrogation is considered necessary for the purpose of investigation. 4. That your actions are punishable under section so-and-so, applicable section 22C NDPS Act. The above is so-and-so. Signed by Hucho ASI who arrests him. So this is the ground set out. There's no basic facts. There's no gist of accusation. There's no full details. There's 3.
I'll see.
My lord. Paragraph 5. Paragraph 5 is relevant, man. This is my submission. That on perusal, the aforesaid notice indicates that no facts which constitute the grounds of arrest has been fully provided to the arrestee. Article 22(1) of the Constitution of India and Section 47 of BNSS 2023 requires that the ground of arrest must include full particulars of the offense. Gist of accusation, my lord. Grounds of gist of accusation is not there. Then the basic facts necessitating the arrest. Basic facts will definitely constitute the all particular best short history. Nothing is there. In a similar substituted case, this Honorable Court principles, Gauhati High Court principal seat in bail application number 629 of 25 in the case of Sakib Chaudhary versus State of Assam has passed the order in favor of the accused on the same ground. Same thing, man. I'll rely on that one. 6. That applicant begs to state that on the expiry of the police remand, the IO of the case, DYSP Vikatochishi NPS, submitted a forwarding letter dated 11/05/26 to the learned Chief Judicial Magistrate Kohima through the official in charge Khozama Police Station and had prayed for forwarding of the accused person to judicial custody. In the said application, the IO of the case has made a categorical statement at paragraph 2 that accused 1 and 2 were examined, wherein accused 1 has admitted to the crime, but accused 2 denied his involvement. The relevant paragraph of the forwarding letter that 11/5/26 is reproduced as under. It is submitted before the Honorable Court that necessary examination of the accused person were carried upon during which accused one Karamo Azaya has admitted to have procured the NDPS 25 sops cases containing 302 grams heroin oblique sunflower with the help of Hisis in Senapati, Manipur by payment of rupees 4.5 lakhs in cash to an unknown source in Senapati and were meant for delivering Dimapur. The Honorable Court may, this is relevant, my lord. The Honorable Court may also know that accused 2 A.L. Keystone has denied involvement in the seized NDPS, which is yet to be as confirmed by the investigation. His involvement is not confirmed even by the IO, my lord, even after keeping in the judicial for 7 days. Now, it is beyond reasonable doubt that even after 7 days of arrest, the IO of the case has failed to collect any information material to implicate accused 2 in the present case. On careful perusal of the statement of IO in the forwarding letter, dated 11/05/26, the IO has brought to the notice of this Honorable Court that the involvement of accused 2 is not confirmed. Hence, at this stage, it is a fit case to grant bail to accused 2 pending charge sheet. Now, my lord, paragraph 7, that the applicant respectfully submit that at the time of arrest, the arresting official ASI Gucha Dazo issued notice information of arrest under section 48 BNS 2023 to the relative of accused 2, informing the arrest of the accused and the ground of arrest. The notice was stated to have been issued by 2 A.L. Taidimas, who is stated to be the brother of accused 2. However, in the notice under section 48 BNSS 2023, time, place of arrest, and venue of custody of the arrestee has not been notified by the police, although the relative of the arrestees lives outside the district of Kohima but lives in Konde village, district Senapati, Manipur. In the absence of the above particulars, it is a clear case of non-compliance of the judicial pronouncement of the Appeals Court, read with section 48 BNS 23. The applicant craves the leave of this Honorable Court to rely upon the judgment of the Appeals Court at the time of hearing of the bail. My lord,
Okay.
The ground for rejection of the bail was that section 47 was duly complied, section 48, which is contrary to the document, my lord. And then,
I'll see that. So that is one. And the main ground is that
my lord,
non-compliance with 47.
because also, my lord, I'll just show lordship judgment. These are from all Gauhati High Court.
Okay.
This is the judgment of 2025. Justice by Justice Kumar Kalita, my lord. Relevant paragraph is paragraph 29. My lord. Paragraph 29. Make it a read. Paragraph 29. Justice Kalita. Paragraph 29. May I read it, my lord? In the present case, notice under section 47 of BNSS served on the petitioner merely state that he has been arrested in connection with Mangadalik PS case number 7 without disclosing the basic facts necessitating such arrest. This court therefore finds that the petitioner was not informed of the grounds of arrest as required by law. The notice issued under section 47 BNS 2023 is devoid of any such details, resulting in a clear violation of constitutional and statutory mandate, rendering the arrest illegal and entitled for bail for the petitioner to bail. Then, lordship, I'll just come to the relevant paragraph. 32 is the most relevant paragraph. May I read it, my lord? Before parting with this case, this court finds it necessary to highlight a concerning practice. While the Constitution requires that an arrestee be informed of the ground of arrest as soon as possible, Section 47 of BNSS.
This was the earlier part of,
Yes, my
2025.
Yes,
At that time, things were still emerging.
yes,
But in this case, he was arrested on which date?
yes,
This person was arrested on which date?
my lord.
No,
Oh, yeah, yes.
in our case,
Yes.
he was arrested on 5/5,
5/5, my lord. He is in judicial custody for
5/5/26.
yes, 5/5. Till today, it is already 44 days, man. This is in total compliance, non-compliance of Section 47, my lord. And even looking at the facts, the IO himself has said that his involvement is yet to be confirmed. I respect the police. They have the legitimate right to investigate, to arrest anybody, provided there is prima facie case. But at least in this case, according to the IO of the case, no involvement has been confirmed so far. If that is the case, it's a clear case of harassing the innocent citizens of the country. My lord, lordship will see another judgment. This is also passed on Gauhati by Justice Kaushik Goswami. Relevant paragraph, just 3 paragraphs, my lord. Paragraph 9. Paragraph 9. In paragraph 9, it is reproduced how the notice of under Section 47 was reproduced, my lord. Paragraph 9. May I read, my lord? My lord, this is the notice issued. Yes, my lord. Then lordship knows, then the next paragraph 13, my lord. Paragraph 13 also, similar judgment in total violations of Section 47, my lord.
Paragraph
13.
1/3.
Yes. 1/3. Then paragraph 15. 15, this Honorable Court has reproduced the relevant paragraph of Vihan Kumar's case.
Okay.
Where it is specifically Supreme Court has held that basic facts constituting ground of arrest should be imparted and communicated to the arrestee. Then paragraph 16, my lord. Para 16. So due to lack of all these facts which constitute ground of arrest, accused have been released on bail pending trial. Lordship, Chief Justice, retired Chief Justice of India, Justice Chandrachud once said, if bail is not considered pending trial, and if a person allows to be languish in a jail for 5 months or 10 years or 5 to 2-3 years, and if that man is acquitted, then who will compensate
That's
that?
different matter.
Yes, my lord.
These are also serious
General
offenses.
law. Yes.
Having a great
Yes.
bearing on society. Anyway, but if there are grounds, certainly one should be.
Yes, ma'am.
So, report is your case diary is coming.
Yes, my lord, I've received the case there.
Let us see the notice. Straight away see the notice, actual notice.
Yes. Under Section 47 BNSS.
What is this? I have this. Well, I have this also. This will do.
Same. Notice
So
under
this one
force.
I received from the IO, my lord. Proceeding.
Original.
Yes, my lord, before I come to the ground taken by the senior counsel, my lord, in regard to the non-compliance of Section 47, your lordship may kindly help me to make my submission. Firstly, my lord, in regard to prima facie, my lord, while senior counsel has submitted that there is no prima facie case in regard to the accused, my lord. But my lord, ask your lordship may kindly see the CD FIR, my lord.
Okay, I think it is also here. Yes.
My lord, I have
This is from the court. So I think it has. But I want to see the notice first.
Notice your lordship may kindly see the.
I have annexed notice. I have annexed, my lord. Page 23, my lord. In my bail application, page 23. Annexure E, page 23.
Grounds of arrest.
Ground of arrest. It is not even mentioned under 47 on the top, just below that I have just referred.
May I read, my lord?
I have just reproduced. He is going to the ground of arrest.
Can you,
My lord, here the
can you
notice.
take up the notice, Mr. Koza? Can you take it? You just take out, let us be on the same page at 47.
Notice
Here it is on
under
page 24, grounds of arrest, right?
Yes,
And
under
the-
page 23, my lord.
This is for A1, of course.
Yes.
I'm concerned about
Keystone.
accused two. Accused two.
Keystone. Yes,
Accused
yes.
two.
Keystone. So,
Page number 23 in the
Position.
in the well application, my lord.
Yes, yes, that is there.
Yes, my lord.
On dates, you were found to be involved in
Yes.
illegal possession.
Yes. Illegal possessions of what?
Illegal, that's not mentioned. Sufficient material and evidence, including
No, my lord.
Case of accusation is not mentioned.
NDPS heroin establishes a prima facie case.
Basic facts. Basic
Custodial
facts. Which
evidence is not. It is not a case of absolutely no. It is not a. It's not like the notice which was
absolutely not.
which was reproduced in the Justice Kolita's order.
Yes.
But it has a little bit of information. But whether it will be sufficient.
No,
That's
my
all.
lord. Here it's
Now I'll hear your submission.
Yes, my lord. Here in the my lord. Before I.
Yeah.
The first in regard to prima facie, my lord. Prima facie that FIR. May I read the FIR, my lord? Only the relevant portion of on 5/5/2026 at around 16:20 hours, while the mobile unit patrol party were performing routine duty under the jurisdiction of Kohima PS, the team detained a suspicious vehicle Maruti Alto bearing number so and so approaching from Kohima heading towards Wisama, Kohima. On briefly questioning the owner driver of the vehicle, Mr. Garamo Asia, he started behaving suspiciously, hence suspecting possessions of NDPS items in the car. The OC Kohima PS was informed, who arrived with independent witnesses at the PO at Wisama to Kitima approach road. On arrival of the OC Kohima PS and independent witnesses, a thorough search of the vehicle was carried out, during which 25 soap were containing heroin, sunflower weighing about 302 grams were seized from the intercepted vehicle. The NDPS items were found concealed in the rear pockets of the front car seats and the car speaker jumper. It is to be noted that the car was in possession of the accused person, Mr. Karoma Azia, and accompanied by the co-accused Mr. A.L. Keystone, who were eventually taken into custody.
just accompanied.
My lord.
Only
That
accompanied.
is the FIR, my lord. And my lord, your lordship, kindly.
You not mention that
Yes.
that in the Caesar list there is no mention of A2.
Nothing.
Where is the Caesar list?
My lord, I'll show you, my lordship. Page.
Because there's I have a document before me, proceeding of Caesar and arrest.
Page 20 of my
But
bail application.
there it is his name is also mentioned. Yeah, yes.
Page 20 of my bail application, man. Under column 5. Page 20 of my bail application, my lord. Caesar memo.
Caesar memo.
Yes, page 20, my lord. Column 5. Under column 5. Person from whom seized recover. Haramo Isaiah. My name is
There is no other Caesar list.
no other Caesar list. My name doesn't appear here.
No, my lord, your lordship, kindly produce this CD, my lord. Here, I'll show you the page number 22. Your lordship, kindly
Stone.
page number 22.
Signature of the person from whom seized.
Caesar.
Yeah, Caesar signature of both the persons are here.
My lord,
At page 22.
that can be it can be signed by anybody, witnesses.
No. Signature of the person from whom it was seized, if present. A1, both have signed here.
My lord,
Person from whom seized.
my submission is this, my lord. Actually, as per the rules, search and Caesar memo, column 5, his name should be there.
My lord, here,
Accused 1 and 2.
Should have been there. Yes, anyway.
my lord say,
Which one should I say? Which page?
page number 22. It is the
22.
Caesar list, yes.
Page
In
22 of
regard
the CD.
to accused 2 years, my lord. My lord, here the seized items was recovered from the vehicle, my lord.
Yes. Vehicle, yes.
Yes. Your Lordship, kindly note that one. It
And
was-
that
it
vehicle
was-
belongs to
it was-
accused one.
It was
that-
released, it was recovered from the vehicle.
The vehicle belongs to
Yes.
accused one. I'm for accused
So,
two.
my lord, that is the facts, my lord. And secondly, the statement of the independent witness, my lord. Statement of the independent witness. Your Lordship, will kindly see page number 6 in the CD. The last paragraph, I've highlighted the relevant portion. May I read, my lord? These two are the independent witness who were present during the who were present on the spot. That they stated on 5/5/2026, their witnesses OC Kohima police station along with the police team had intercepted a vehicle Maruti Alto bearing Sonso at Wisama, Kohima, which was approaching from Senapati and heading towards Dimapur. There were two persons in the car, two persons, one driving and other accompanying. OC Kusama PS and team lead the search of the car in presence of them and the accused persons who were in the car. As the police team progressed with the search, huge quantity of suspected heroin, sunflower packed in 25 separate shop cases were found concealed in the rear pockets of the front car seats and the car rear speaker chamber. As the police pulled out all the shop cases containing the suspected heroin, they were weighed in their presence and found it to be approximately 302 grams in total. Accordingly, the seized NTPS case were packed in one bag and sealed in their presence, and after which the police team seized the suspected NTPS and the vehicle and arrested the accused person in the car. So, my lord,
This proper, okay, that's okay. The property seized, which you are showing, right?
Yes.
It has in column 5, it has name of Keystone.
only yes, my lord.
No, this has Keystone. This is,
Yes,
it's
yes,
not annex. It has Keystone. Anyway, so this
So, my
is the statement of the independent witness, right?
Yes, it is the statement of the independent.
Can I see the statement of the persons themselves? Must be there. No, he has denied and A1.
Yes, my lord, the
both of them
accused
have
number
said-
1 has admitted, but the accused number 2 has denied, my lord.
Yes, what has he said really?
My lord, here the statement accused number 1 he has admitted, but accused number 2 has denied. But my lord,
Yes, I found
this
it.
cannot be relied, my
I
lord.
found that statement.
And my lord, your lordship may kindly see the CD page number 15. Page number 15, my lord.
Okay. He
Yes.
claims to be completely unaware that he was.
Well, I'm absolutely. I was
That is
just.
his statement, of course.
I was just a
That's
person.
the statement,
But
my
we
lord.
do not know whether.
Yes.
That's why I said, what did the main one say? Did he admit or something?
Accused number 1 has admitted, my lord.
Accused one is not before December court minute.
Yes.
My lord, page number 15. Page number 15 in the CD. The recording CDR of accused person. The analysis CDR. Receive the mobile data CDR of the two accused person. Accordingly, necessary analysis is in progress. Note, as per the study and analysis of the CDR of the mobile phone number of the two accused person, it is clearly indicate that both the accused person, accused 1, Mr. Karamo Azia, and accused 2, Mr. A.L. Keystone, have been frequently traveling from Senapati, Manipur to Dimapur, Nagaland, together since November 2025 till May 2026. They are
Anybody can travel, my lord.
No, my lord.
Nobody can stop. Nobody can be stopped from traveling. I am traveling every day as an advocate. That does not show that I have. There's no prima facie to show that I have committed any offense for traveling frequently. That cannot be a wrong submission.
No, my lord, here the
By traveling, from out of my traveling, if police can show any prima facie that I have committed offense, then yes, I'll fairly consider, I'll fairly submit. But here, anybody can travel anytime, 100 times. In fact, many counsel appearing before the Supreme Court, they travel from Dimar to Kohima every day. That does not commit any
Karamo.
prima facie case.
But
My lord, these two are authorized, my lord.
They are from the same village. They are from the same
on
village.
his statement, he says that it emerges that he knows Mr. Karamo for a long time.
Yes, they are from the
But
same village.
he does not state that he has been traveling with him for a long time.
Yes.
Huh? But that
But
is
from
what.
since November 2025 to till,
But the CDR says that CDR has found that they were traveling together for a long time.
yes, my lord say
But he
in
said
the
that-
statement of the accused number 2,
Think about-
he said that first time he accompanied the accused 1 and went to Dimapur. First time travel. But here it says that
Yeah,
there are
that is what
frequent
indicates
travels.
that is what
Yes.
I'm trying to get.
So, my lord, here what I want to say is that they are actively involved in this illegal business.
Where is that prima facie case?
My lord, by
Where is
the
that
reporting,
case?
it says that they are involved. And the
Is
second,
there
my
any
lord,
material evidence to show that I have involved?
and my lord, in the my third point is, my lord, the seized items are commercial in quantity.
Commercial quantity.
Yes. And it is cognizable and non-bailable offense. And my lord, in
Commercial
Figures are higher.
Commercial quantity will be determined only if the compliance of section 47 article 22
Oh,
1 is complied.
my lord,
That is what Justice Kaushik in his judgment has said.
Come from Vihan Kumar.
and my lord, my fourth ground, my lord, in regard to violations of 47 and 48, my lord. Your lordship may kindly see page number 23 of the bail application.
Yes. Yeah.
Kindly allow me to read this. This is an example. Grounds of arrest. To Mr. A.L. Keystone, son of so-and-so, resident of Kongdae, date time of arrest 5/5/2026, case reverse on so. I, name of the arresting officer, Puchu Tazbo, rank ASI, posted at Kozama, do hereby inform you that you are being placed under arrest under the provisions of PNSS Act. The specific ground of your arrest are as follows. Number 1, that on 5/5/2026, you were found to be involved in alleged offense or illegal possessions. That sufficient material and evidence, including so and so 302 gram NDPS heroin, establish a prima facie case against you. That your custody interrogation is considered necessary for the purpose of investigation. That your actions are punishable under section 22 clause 3 NDPS Act clause 3.
All right.
Yes.
No problem.
And my lord, this is in accordance with Article 22 clause 1 of the Constitution of India and section 47 of PNSS 2023. My lord, here the brief of the case, the prefects already stated in that he was arrested on 5/5/5 and he was in possession of illegal items, that is 302 gram of heroin. This is the facts, my lord. It is already stated in the grounds of it. And the second thing, my lord, in the page number 25, your lordship kindly see page number 25.
Of the petition.
Yes, it's page number 25.
48.
Notice of information of arrest under section 48.
That's okay.
Yes, yes.
They have written something.
Here's the name to A.L. Titamas. Relation with accused person is brother. You are hereby informed that the below noted accused person have been arrested in so the above mentioned case. The case is bailable, non-bailable. You are also informed that you may seek bail in the jurisdictional court as per law. Grounds of arrest has been mentioned in the para 2, 3, 4, 5, 6, and 7. Well, under 47, the information was given to the brother of the accused one. So, my lord, as per the report, it's
He's not
very clear that
contesting
there is no violation of section
He's not
47 and
contesting.
48, my lord.
He's only agreed. He
It's
said
already compliant, my lord.
47 is not anyway. Heard, learned senior counsel, public prosecutor. Have a seat, please. Also, invoking the jurisdiction under 483 BNS. The a bail petition has been filed seeking bail for the accused A.L. Keystone, who was arrested in connection with Kusama PS case number 2 of 26 under so and so sections. It's right from there. He was arrested on 5/5/2026. The allegation in the FIR dated 5/5/2026 was that during a Naka checking within the jurisdiction of the said police station, a vehicle vehicle within bracket Maruti Alto bracket close bearing number NL07 CD 5992 was found approaching, and upon suspicion the vehicle was searched, and from the rear side of the vehicle 25 soap cases containing 302 grams of suspected heroin were found. The vehicle had two occupants, being the present petitioner and the co-accused. The present accused, Mr. Keystone, and co-accused. Mr. Joe, Learned Counsel, Senior Counsel, primarily contends that notice under 47 BNSS have not complied with the requirements of law crystallized in various decisions, including decisions of this court. It is also submitted that the present accused was an innocent passenger of the vehicle, and he had no idea about presence of any contraband in the said vehicle. It is stated that in the scissor list annexed with the petition, the name of the co-accused finds mentioned, but not that of the petitioner. It is also submitted that in his statement, before police, they completely denied any involvement. Stated that he was just traveling with the other accused. The scanned TCR is available. The learned PP also produces the up-to-date case diary and strongly opposes the bail at these states. He submits that there is due compliance with the notices under section 47-40 after referring to the same from the records. Full stop. Showing the statement of the independent seizure witness, it is submitted that he has supported the seizure as alleged in the FIR. It is also submitted that the CDR materials indicated in the case diary also are incriminating with regard to the petitioner as well. I forgot. In support of his contentions, the learned senior counsel with the petitioner relies on the following decisions in the earlier part of this number. I have given my consideration to the materials and considered the submissions, including the case laws. This you reproduce. The remaining dictation I will take it from here. Stop. 47 notices then marked. The notice under 47 given to the present accused may be reproduced here in the. Okay. I'll keep this and give it back to you, man. Complete the petition. Think about it a little bit. See the case diary again. This also. Short break. Okay, I'll march out.
Much obliged.
Complete the admission, perhaps. Yes. 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 No, I can proceed to complete this.
For orders, item number 14.
Yeah, 14.
My lord.
14 we have already done.
No, my lord, 13 completed, my lord.
Oh,
14 was,
okay.
yes, 14 was left inadvertently.
Oh, same then. It's same.
My lord, service upon all the respondents were awaited, my lord.
Okay, that's all. Mr. Devnak appears through online mode and submit that service upon how many respondents are there?
All total, my lord, 4 respondents.
The 4 respondents is awaited. List the matter after 5 weeks. 5 weeks. Okay.
My lord, deeply obliged. My lord. I'm obliged.
Continue.
For admission, item number 7.
Is this matter, madam?
Please, Lordship, Lordship, on the last occasion, Lordship, this honorable has directed me to take an instruction, Lordship, with regard to the letter dated.
Oh, yes, I
Yes.
remember. We've seen the earlier communication.
Lordship, earlier communication from the undersecretary to the deputy commissioner. And we are still awaiting.
Not received.
Not received.
Madam, your good name, please.
Panglamla.
Learned counsel for the, we are on, okay. Now? Right order dated 12/6/2026. The learned PP was directed to take an instruction with regard to a communication dated 3/3/2026 from the government of Nagaland to the DC parent regarding rescinding the earlier communication, rescinding RESCIND, rescinding the earlier communication for initiation of criminal proceedings against the petitioner in view of the ongoing disciplinary proceedings. Today, Mr. Jimomi learned submits that the instruction is still awaited and he may be given some more time. Praise Allah. List after
vacation.
After vacation or next week?
After vacation, Lordship, since
After vacation. List immediately after the vacation.
For admission, item number 8.
This is to do with Zimma, Lordship. On the last occasion, Lordship.
Oh, this
Lordship. To take instruction, Lordship. This is the photocopy that I received, Lordship. This.
Did they rely upon some object?
Lordship.
No.
This is the envelope, Lordship, and then it has been executed.
It has not yet been exhibited.
It has been executed.
Already. During the trial. So it can be released, I think. It is exhibited. It has been exhibited during the trial.
Lordship, no, the trial is.
No, the trial has not yet commenced.
It is marked as an exhibit.
Trial has not been.
I see. It is sealed here.
Lordship, it is already been sealed. Lordship.
Sealed here.
With
Yeah, in my experience is that in such situations it becomes a problem because electronic document, right? It's sealed. That is the difficulty. If it is if it is not relied upon object and or if it is already exhibited, then of course it should be released.
May I submit, my lord? Lordship, in that regard, even if it is sealed, if it is an exhibit, Lordship, there is no finding. The impugned, may I take my lord to the impugned order at page 22, Lordship. I filed the Zimma application before the learned trial court, and this is the order, page 22, my lord. It is order dated 26 March 2026. If my lord will have para 3, the applicant has, may I read, my lord? The applicant has prayed for release of the seized mobile phone as the case is already charge sheeted and no incriminating evidence is available. Learned public prosecutor has opposed the prayer, submitting that the said mobile phone was purchased out of proceeds of drug trafficking and is connected with the offense and is crucial for evidence as an exhibit. Consider the submissions. At this stage, the prosecution case indicates that the mobile phone is not only a material exhibit, but it is also alleged to be derived from the proceeds of crime. The device may further contain relevant data pertaining to the commission of the offense, which is yet to be fully examined. In such circumstances, release of the said mobile phone at this stage is likely to prejudice the prosecution case. In view of the above, this court is not inclined to release the seized mobile phone at this stage. Lordship, being aggrieved with this order, I'm before this honorable court today. My lord, the This is a case wherein the accused person was arrested 3 months after registration of the FIR, first lordship. And this particular phone was purchased, was seized when I was arrested, and it was purchased right before the date of my arrest, lordship. Therefore, at the time of registration of the FIR, this particular phone was probably somewhere in some factory getting assembled, my lord. Therefore, this phone is not a proceed of crime. This phone is not a material exhibit. There is no finding to that effect. And also, my lord.
No, the learned session judge has mentioned
Yes, my lord.
the submission of the prosecution that it is a relied upon material object. That's for sure.
Lordship.
Whether it will proceed of crime or not, that's another. That's a matter of evidence.
Lordship, yes. So, lordship, whether it is a material exhibit, there has to be facts and findings supporting this, my lord. And therefore, I'm aggrieved because this should have been relieved on Zima for the reason that if, my lord, as agitated the other day also, if this were to be permissible, then any property of an accused person having substantial value may be confiscated, may be seized
It has to have
mechanically, my lord.
linkage with the investigation and the charge sheet. If their properties cannot be given as a material exhibit just like that.
Lordship, yes. That is my case, my lord. That is my case. There is no findings.
Some found from someone's pocket.
Yes, lordship.
And it is some TV is seized.
Yes.
There's no relation, absolutely.
Lordship.
So, but here that is their contention. Anyway,
Yes.
it has to
Now,
be seen.
the problem is since it is already been sealed and packed.
Lordship, that cannot get in the way, my lord.
That is the difficulty.
It is only by authority of law that the police could have seized and the court ought to have released this, my lord, because there is no findings, lordship. Even the call details record was examined by the investigating officer, and he has made this a part of his charge sheet. But there is no entry insofar as this particular phone is concerned. There is no additional prayer for additional filing of additional charge sheet. The data from this phone was extracted, and no material findings is there. Nothing incriminating is there, my lord. Also, lordship, as stated earlier, the argument of the learned PP was that this was a proceed of crime. Proceed of crime as defined in the PMLA Act, my lord. This act is paramateria for the reason that my lord knows that the offences of the NDPS crimes mentioned, my lord.
It can be, but at this stage anyway.
And my lord, also confiscation, my lord knows too well that it comes only at the end of the trial under CRPC 452 and NDPS. Therefore, the prosecution could not have circumvented this whole procedure and go for confiscation at this time. I'll produce the exhibit anytime, my lord, if at all it is released to me, because this is something that has nothing to do with the crime, my lord. And I'm relying on a decision of the Honorable Delhi High Court wherein ganja and cash was recovered from under a pillow, and the court held that without any finding, without prima facie indicating that the cash was a proceed of crime, lordship, it could not have been presumed that the money was.
Because if it is released to the petitioner, how will it be exhibited? Because it has been sealed, right?
Lordship, it has already been
the trial. I think best will be the trial is about to begin.
Lordship.
So we can direct that this material exhibit be done expeditiously, and thereafter he can file an application for the learned court. Right? Because whoever is going to exhibit this, it can be informant also. It can be PW1 also. Because as I said, from my own practical experience, I have seen also that it's considerably handicapped actually. The integrity of the evidence has to be maintained since, rightly or wrongly, it has been given as a material exhibit. That is what I feel. Anyway, so we have to see both sides also. This last order, please have a seat. Para 1, 2, 3, just lift. Para 1, 2, 3, just go through. So, the Mr. Kira, the learned counsel, has fairly drawn attention to the impugned order dated 26/3/2026 passed by the learned trial court, mentioning the submission of the prosecution that the mobile phone in question was purchased out of the proceeds of crime, within bracket drug peddling, and has been and connected and is crucial for evidence as an exhibit first. With regard to the earlier query of this court, the learned people has submitted a copy of the photograph of the envelope where the mobile phone is stated to be sealed, and it mentions the case number and the words exhibit full stop. In this context, the learned PP submits that the said mobile phone is in a sealed and packed is in a packed and sealed condition and marked as a material exhibit to be exhibited during the trial. The same is also the said contention of the prosecution is also reflected in the impugned order. Full stop. The learned counsel for the petitioner denies that the mobile phone is purchased with proceeds of crime and that it was purchased very shortly before his arrest in the case, and that it has no connection to the date of the alleged offense. Further submitting in this context that he was arrested 3 months after the alleged incident. Given my consideration to the entire matter, full stop. So it's clear that the mobile phone which was seized in connection with the case is a material object has been marked as a material object for exhibiting during the trial. Full stop. And the learned prosecution, the contention of the prosecution that the being earmarked for exhibiting as ammo, it is in a packed and sealed condition. Full stop. Broadly on these grounds, the impugned order was passed rejecting the prayer for interim custody. Full stop. Upon giving my anxious consideration to the matter, I am of the considered view that within the ambit of revisional jurisdiction, this court does not find any perversity or material irregularity or gross error of law in the impugned order passed by the learned trial court. Therefore, the said order is hereby upheld and confirmed, thereby dismissing this criminal revision. However, during the course of the trial, if the prosecution explicitly exhibits the mobile phone as a material object, thereafter, the petitioner, as the purported owner of the same, would be at liberty to prefer an application before the learned court for release of the same. The revision stands allowed and dismissed and disposed of by aforesaid.
Nice.
Much time.
For hearing. Number 17.
Let's take a call. How many hearings are planned? Because I'll be rising today at 2:45. I'm planning because I have some work before I leave. Tomorrow evening I'll leave. But so I'll take a short break before starting the hearing. Which are the matters you are ready? So you are ready,
My lord, I'm in 18.
18. This we can do perhaps. Jail appeal, right?
Yeah, jail appeal. Amicus,
You are amicus. Good. And 20 is adjourned. We have 3 matters.
Yes.
All the councils are ready for all the matters.
My lord, item number 17. My lord, here the appellant they have filed IA this morning.
Yeah, they filed an IA.
Yes.
So what is this matter? Otherwise,
The matter is regarding withdrawal of workers' pension.
withdrawal of
Pension.
pension.
Yeah, illegal pension. Yeah.
Okay.
So it was a criminal revision filed in the year 2018.
I see.
My lord,
Okay.
the IA
The IA.
filed for conversion of
Uh,
criminal revision into
appeal.
criminal. Yes. this case is registered
That's
as
permissible.
criminal revision.
Is that permissible? I'm just refreshing.
Yes,
The appeal into revision, revision into appeal.
it's permissible, yes, Your Lordship, under section 401 clause 5 of CRPC.
I think so.
Yes.
It's statutorily provided, I think.
Yeah.
Anyway.
It was
so
advised by one of the lordships.
And criminal jail appeal is there. And what about this matter, 19? Who's there for 19? 19, item 19. You're there, madam. This is the 23 matter. Just hold on, I'm just planning. Well, all three may not be possible, but we can touch one or two maybe. You are ready for the hearing, madam? I'm ready for the, let's see. Okay, whatever we can do. I'll take a short break and then we'll come back. So this IA is for conversion.
Yes. Yes, Your
Okay.
Lordship.
So if we convert it, then hearing would not be possible.
Yes, yes, Your Lordship.
Okay, so let us, I just come back.
Yes, yes,
Then
Your
we'll
Lordship.
take a call on the IA. In
Yes,
the
sir.
meantime, let us just take out the statutory provision.
Yes.
I also remember refreshing, that there is a provision.
Yes. Achha, please.
Sir, our meter will be
Our dear sister, Mola,
So, you want to hearing next? Not on. Oh, I do. Oh, itu polisi ya?
sure.
Now we have only.
Oh, yeah, yeah.
complete order pass to there is a 6 floor there.
Order to mo dia.
They gotcha. Huh?
Oh,
With orders item number 26.
Oh, yes.
May it please Your Lordship, Your Lordship, we have filed an IA in this matter for conversion of criminal revision
CRPC.
petition, criminal revision petition number 10 of 2018. to appeal. Your Lordship, the criminal revision petition was filed against the partly impugned judgment dated 30/10/2018 and partly impugned judgment order dated 30/10/2018, passed by the learned Principals District and Sessions Judge Dimapur, by which the applicant was convicted for offences under section 465, 468, 471, 419, 120B, and 34 IPC and sentenced to undergo 1 year of rigorous imprisonment. Your Lordship, now we have come to file this IA in this matter because your
Done. You have written also in your application 4015. Yeah, please complete what you're saying.
Your Lordship is too well aware that the right of appeal is a statutory and substantive right, and that revision is quite limited compared to it. And then it was.
You should always file a appeal.
Yes, yes.
No question of file. In fact, revision may be barred also.
Yes.
Right? But this is
And it was advised by one of the lordships to take the steps for appeal.
Sure. No problem. These flexibilities should be when analyze the appeal for application reason. Okay, we'll convert it and then re-register.
Yes, much.
Because he's 1 year conviction. He must be on bail.
Yes.
Yeah. Heard W1. Let me prosecutor for the state. The instant interlocutory application has been preferred, seeking to invoke the provisions of section 401 within bracket 5 of the CRPC. Now we have to find the equivalent provision of BNSS with
442 clause 5.
442 within bracket clause 5 BNSS. Full stop. It stated and submitted that the petitioner was convicted and sentenced by judgment and order dated convicted by judgment dated 30/10/2018 and same date, right? Sorry, the earlier judgment convicted and sentenced by judgment and order dated 30/10/2018, passed by learned Principal Session Judge Dimapur in RC 04 of 2006 under section so and so para 3 right. Full stop. For such conviction, he was sentenced to, for all the convictions on a 1 year sentence.
1 year.
He was sentenced. He was imposed with a concurrent sentence of 1 year RI. Full stop. He preferred, the petitioner preferred and preferred the present revision, but subsequently came to know that a statutory appeal lies against the impugned judgment order, and accordingly seeks to invoke section 4015 of the criminal procedure to convert the instant proceeding into an appeal. Section next time. Learned public prosecutor fairly submit that he has no objection. Section 4015 CRPC within bracket 442 may be reproduced here in the stop. A person convicted and sentenced under criminal law is conferred with a substantive right of appeal to the appellate forum. Full stop. And there is no reason to not invoke the provisions under the aforesaid not invoke the aforesaid provisions of the criminal procedure law to allow the prayer of the applicant. Accordingly, the instant criminal revision, accordingly, in exercise of powers under so and so section dash in the instant criminal revision being so and so, give the number is hereby converted into, may be converted into a criminal appeal. The registry shall register and renumber the same. And thereafter, it will be taken up for hearing.
Yes, sir.
The matter has already reached the stage of hearing. Therefore, after the aforesaid exercise on the part of the registry, the proceeding in the form of criminal appeal may be put up for hearing. Finally, right? I understand.
After vacation.
Huh?
After vacation.
Yeah, after the vacation. LCR is available.
Yes.
The TCR is already available.
Much obliged.
Flexibility should be there in the law. Full flexibility.
But
The other way also it should. be. For hearing, item number 8.
May I please, Lordship. My Lordship, I am the amicus curiae here. The appeal is against the judgment and order passed on 26/07/2018, my lord. And by this judgment, the accused in jail was convicted to undergo rigorous imprisonment for 10 years. This is under POCSO as well as under certain penal sections of IPC. Rap. Now, it's my
It's a POCSO matter.
POCSO.
So the informant has been.
Yeah.
Not.
Yes.
Notice is enough. Okay, sir, please go ahead.
My lord,
10-year sentence.
yes, judgment is short, so may I read the judgment?
The judgment of.
For bail hearing,
Just judgment is there, on judgment.
for judgment. WBC 20 of 2026, Kohima bench.
I'm reading the operative part. In my considered view, having found that the exercise of power under section 110 of the Customs Act regarding seizure of the areca nuts was bona fide, the said exercise of power is upheld in judicial review. At the same time, the court is of the view that vehicle in question should be released to the respondent number 7, the owner, on suitable conditions. Accordingly, that was directed. The writ petition stands dismissed subject to the aforesaid observations and directions. A copy of this order will be furnished to the learned counsel for the customs for information and need.
Deeply.
Bail hearing, bail application 906 of 2026, principal seat.
Thanks, please.
Yes.
Yes, Mr. Biswas.
But today the victim has completed 399 days and
Yes.
3 witnesses have already examined.
Mhm.
And the highlight of the whole case is that the victim has refused to get a medical examination that your lordship has already peddled earlier.
Yes, you have mentioned.
Yes.
And the victim has been examined, right?
Excellent. She refused for medical examination.
Okay, that's okay. No, no.
There is a report also, evidence of that body officer also. And my lord, amicus curiae regarding last, she's also appeared today.
Okay, Ms. Brown is also here.
I pray before lordship, since the 3 persons have already been examined, my lord. So, my lord, if you lordship kindly consider the bail, my lord, he will
Okay.
regularly attend the court and till the end of the trial.
My lord, with all respect, my lord, victim, my lord, a 15 years old girl. She was first examined, my lord, on 6th of August 2025. Subsequent on that day, cross was reserved because some problem, my lord. Subsequently, again, cross of the victim was done on 2nd of September 2025.
Okay.
But on that day also, my lord, further, it is reserved for further cross of the victim, my lord.
The full cross of the victim is not yet completed.
Malat, as per the scan TCI, Malat, we have up to Malat 2nd of September 2025, and on that the further cross examination will keep reserved. As police has already
the scan copy is only till September 2025.
No. Malat, scan copy you have received in the Malat after May, man, in May.
Okay.
But subsequent to that, Malat, on the 6/11/2025. PO transferred, and since then that is the position, Malat. PO is transferred, that code is vacant.
Maybe
since 6/11/2025.
How come it's?
There also I have submitted earlier. But
Oh yeah, I remember now.
no new appointment is there.
No new appointment is there. Yes, it's vacant.
But now the Malat main issue is that, Malat, in such a case of POCSO of 15 years, and in the whatever in the Malat in our evidence, Malat, in SIF, as well as the part of the Malat cross, it is says Malat that implicated the Malat accused.
Some part of the cross examination is left.
Still is left. On lastly, Malat cross examined on 2nd of September 2025.
That's a long time.
But since 6/11, that code is still vacant, Malat, and that is the position. Now, Malat, if this honorable could directly any Malat, but it is up to the Malat authority, Malat, to authorize any other court to run as a special.
High court said
Malat.
Administrative.
But that is technical, Malat. But until and unless, Malat, full part of the evidence, Malat, SIF already done, but cross part, Malat, is complete. Malat, there is every chance of Malat interference with the Malat. 15 years old girl.
Malat, my learned friend is submitting and tracing of this 15 years. She has declined to get a medical examination. What is her age? Time and again there was a request to her. She said, no, I will not allow it. That is the fact, my lord.
Mm.
And regarding the non-ability of this POCSO judge, how long I will be remain?
That is not, that is certainly not your fault. That's okay. Not your fault. Anyway, should I?
So, my lord, any condition, my lord, I will attend the court regularly. No question of influence because everything is over.
Amicus,
My
Madam,
lord, she is appearing.
submit.
Your Lordship, I would still insist that the cross-examination of the victim may be done first, Your Lordship. And also, as a learned counsel is saying, that the medical examination, the victim has refused the medical examination, Your Lordship. Those are matters of trial, Your Lordship. We cannot come to a conclusion.
Now you can say very well that what is the outcome if medical evidence is not available? How you determine the age that she is a minor or major? That is the big fact of the POCSO case.
Birth certificate already, my lord, seized, my lord. Birth certificate is there, my lord, it is seized.
Okay.
As per date of birth is 4/3/2010.
I've noted down. So the learned amicus says that it would be prudent for the cross to be completed. Medical examination refusal is a matter of trial. Learned counsel, Mr. Biswas, says that that is a point to be noted. That's a decline medical examination. Chances of interference submitted by the prosecutor. It's okay. I'll look into it.
My lord, only one fact, my lord, as per the, my lord, date of birth is 4/3/2010. 4/3/2010 and FIR dated 13/5/2025. So exactly, my lord, 15 years 2 months on the date of occurrence.
Okay. Okay. That's all?
My lord.
Okay. Close. Quickly. Give it a question. Okay, we can log off.
Right, my lord.
Also, this come now. Stand open. Keep it with the. So. Did you look into that aspect? Did you look into that aspect? Right. In this case, in our case, no. You can log off. Yes. Yes. Councils are there. I would just appeal to you, learned counsel for these two matters, 19 and 21.
Yes.
Right? Councils are here.
Yes, ma'am.
You're for.
I'm for the respondent in item number 19, madam.
Now, item number 19 is okay. Now, item number 19 is a 23 matter. So 22. Would you like to get the matter fixed on
Yes,
Tuesday?
yes,
This Tuesday.
25, madam. 25th of this month, madam. Next Thursday.
Next Thursday.
Yes, ma'am.
Or Tuesday.
Thursday.
Thursday.
Yes, ma'am.
Some matters a bit fixed on 25th also, I believe. To Tuesday, I don't remember so much. Tuesday might be a better option, but you think about it. If you are insistent, then which one? Thursday or Tuesday?
The petitioners have left. So they have to take as causes prayer, my lord.
Okay.
The date was fixed 25th.
Oh, he said that.
Yes.
Due to some time constraints, the matter could not be taken up today. Item number 19 is fixed on 25th of this month. Okay.
My lord, I can make mention item number 21, madam. This item number 21.
Yes.
If this matter can come up on 22, madam, Monday, next Monday.
This Monday.
The coming Monday, madam.
Coming Monday. Or it's is there any interim order? Interim orders there?
Yes, madam.
Can it be? How about fixing it after vacation? I'm just asking. 26 matter. You know, if you have some, if you have an interim order, and it is a 26 matter, it can be. We can fix it, say, on the day of reopening, also 13th.
Madam.
Is it okay?
It's okay.
The list on 13 July.
Interim continue.
The same reason. Time constraints.
Much obliged.
Now, in this matter, yes,
Madam.
I think if the court has come to a finding
Yes.
that the victim is aged below 12 years,
Yes.
then I think it made an error in the sentencing.
Yes.
Because if it is, as long as it is within the legally permissible limits, there is absolutely no issue. I mean, that is a matter of final adjudication of the appeal. But if it has been, if the minimum sentence is 20 years, and the court by mistake has imposed 10 years, then it has to be remanded back till from the stage of to be taken up again from the stage of sentencing. Kindly let us see. So let us just reorient ourselves, sir, and let us see the finding of the court on the age factor.
My lord, I have prepared small gist of argument.
Yes.
Basically, the age of the victim is not proof. That's what I'm saying. Not proof at all.
So if that is the case, because the court, the judgment is structured reasonably nicely, I've seen. Will the court make such a mistake? So that is why maybe the court has found that the age is not proved, but minority is proved. Age is below 12 is not proved.
But
that is why section 4 has been taken. Just let me,
the two foundational principles in POCSO cases, my lord, lordship is aware. One is first, the age of the prosecutrix victim has to be proved first. Secondly, if at all the accused has committed the offense, these two has to be proved. But first principle is that age has to be proved. So legally, in my respectful submission, age is not proof in this case. This is my argument. Because to prove the age, my lord.
That there are two kinds of age determination in POCSO. One is the first and basic age determination in POCSO is minority.
Yes.
Below 18 years.
Yes.
Otherwise, it won't be POCSO. It can be adult rape or something.
Yes.
But not POCSO.
Correct.
Later also. So once the that is proved that it is below 18, then it will come within the ambit of POCSO.
Well,
now, POCSO has some aggravated areas, like below 16, below 12.
Correct.
So now if the prosecution tries to, put him there, then that aspect has to be proved beyond reasonable doubt, that below 12. So this thing.
Age is not a disputed issue now.
No. Age is not the minority is not a disputed issue, or the age of 8, 9, 10 years, you said, no?
Yes.
10 years.
10 years.
Has that been accepted by the court? Because why did the court invoke? Because this can be a little confusing. I understand this. What is the POCSO Act? Give me the IPC also. IPC and POCSO about choice. IPC also, because the POCSO section 4 has two limbs.
Yes.
Can you take up the POCSO?
Yes.
Wait. One copy to serve also. Section 4 has two limbs.
Yes.
Even I have learned once at some point of time that section 6 we know is aggravated. It's mentioned as aggravated and is minimum 20 years. But section 4 also has a aggravated limb, which is subsection 2. Can you have a look? Whoever commits.
May I read it, my lord?
Yes, please.
Whoever commits penetrative sexual assault shall be punished with imprisonment of either description for a term which shall not be less than 10 years, but which may extend to
assisted by, kindly give your names, sir.
Okay.
Take down their names. Who addresses and who is amicus curiae, who is
Yes.
appearing as amicus
Yes.
curiae for the convict appellate and addresses his arguments. Full stop. Due to paucity of time, the arguments on behalf of the prosecution represented by Mr. E.S. Zimoni and Mr. Emuzi, learned counsel for the amicus for the informant shall be taken up tomorrow. The matter is kept as part of list tomorrow. Come as a list. I'll sign it and give it for the listing, right?